So, without further ado, we're going to go, if you go to the master file here, for those who don't know, there's the sub menu here if you have access to it. Just to make it easier for you, I made this step-by-step list of a reasonable order in which to do things. You may deviate from this order, and you don't have to ask my permission to do so. I'm going to tell you to kind of study and come to your own determination. And when I'm telling you guys that, I'm usually balancing my time, the projects that I'm also working on, and I really can't afford to dedicate to tell you how I came to these different conclusions if you haven't put enough studying under your own belt. But this is what I'm passionate about. It's the very necessary research from this standpoint. And don't be judgmental or critical, because I'm not saying that this is necessary. I'm not saying it's required for you. This is where my research has led me and the team that I'm working with, and we're doing these things for us. And I'm putting this information out here because people are asking for it. People are asking for the updates. This is why I'm putting it out here. I'm not suggesting that this is a national solution. That being said, the majority of everything that's being done in the master file is based off of the research primarily that we were doing for ourselves, and we are Moorish Americans here. So although a lot of it is applicable to just people with birth certificates or U.S. vessels and persons, the majority of it is tailored to Moorish Americans. Everything that we've done with our estate, custodianship, and executorship, we're considering the fact of our proper status as Moorish American nationals. So that's a further reason why you have to be able to do your own research, dissect what we have here, and structure your estate and make it personal so that you can understand it. So please take that into consideration. No two people's demonstration are going to look the same. Okay, so now here's the order. So the first thing is the will and testament. And when you record the will and testament, you're going to keep a true copy with the receipt. So I said that in one sentence, but it may take you some back and forth to get this done, because not only do you have to get through the maze of getting the will recorded, you also have to have a copy with the receipt, just so you can have the evidence of it. But that we'll talk more about that later. And the one reason why the will is step one, because in the will, one appoints the executor for his estate. So you want the record, the court of record, with the appointment of the executor for the estate, which is why you want to get the will is a record, but you want to get it on public record. So you're going to see that the majority of times when you do get the will even secured or recorded, registered, or whatever you want to call it somewhere, the first thing that custodian is going to tell you is, this is not a public record. And if he doesn't tell you, you should ask, is this considered a public record or not? Usually they'll tell you straight away, no, it's not considered a public record. So this is key why you want to have the true copy of it and the safekeeping receipt or whatever other information that you as a custodian of even the true copy can demonstrate and put it on public record. I believe it's significant to put it on public record based off the research that I've done. And and I don't want to go into all that research because this is already going to be long enough. This is where you have to go and do your own research and see if you find if it matches with what we're laying out. So but you do that because now that you have this official record, you can put it on public record if necessary, or maybe by a certification. There's different ways you can research that, but it's evidence of the executor. And later on, you'll see when you go through the demonstration, when you actually go through the notes, which is you would click this thing that says addendum. It'll take you to a whole nother file, and it's going to further explain with what the definition of an administrator is, bringing more clarity to you why it's significant that an executor is appointed for the estate. The estate, let's just say generically, being the vessel that's identified by the birth certificate, or the property that's identified by the birth certificate, or the person or the estate that was registered to the person upon birth. That's what we mean when we say the estate. So based off of when you get into the estate law, which they're, of course, they're administering business and commerce. You're doing things under estate and trust law, and then they're doing things under commercial law. Then they're doing the public policy and different things. But when you get into the estate and trust law, you understand why there has to be the office of the executor has to be occupied, because when it's not occupied, that's what's taking you down the wrong road, putting you under the administration and enacting certain war powers and other different policies, you know, against your estate because it's not occupied. So this executor thing is very important. But but I hope you can see the flow now, which is first the will. The will creates a record of executorship. Now you can have your executor letter so that you can give notice of executorship. The estate's not abandoned, and this changes the record. This changes the record under the estate and trust law, or you may say it changes the status under the estate and trust law as deals with the vessel or the person. So that's what the notice of executorship does, you know, when you do the research on it, because now there's evidence of executor, and these general powers of administering the estate can't take effect because, well, now for Moorish Americans, this is why it's key, because what is this administrator doing? Well, we already know if there's no executor, which translates to a captain in admiralty or whatever, you know, a captain or a commander. If one isn't appointed or on record or competent, or depending on what jurisdiction he's in, then administration occurs. But if one is there, then they have to take into consideration the because the even before the executor. So and this is we didn't mention this, and so I'm mentioning it now. Before you even look at the executor for a vessel, or the commander or the owner, you're looking at the flag, the nativity, and the nationality, right? So I kind of, I didn't mention that because we're doing something else as far as correcting nationality. Here we're just dealing with this estate stuff. So I will say it like this: the executor and the owner of the vessel, for the purposes of correcting our estate, is essentially, let's just kind of say, the same person. They're not, but they're like the same person. You control both of those as the owner of the vessel and the executor, the commander, the one that's operating the vessel. So your nationality has to be on the record, because the owner of the the nationality of the vessel depends on the owner of the vessel. So when we're correcting our status, dealing with ownership, or the executorship and the rights of the estate, we also have to put our nationality on the record, because all of the different treaties and things come into effect. Now, again, we haven't seen this demonstration that I'm talking about, but this is what the law has been set up for. And all of this can't be really recognized in this discussion about the master file, because some of the things that deal with the national character of the vessel as relates to Moorish Americans have to be handled on a national level. And that discussion can be had also, because I'm involved in a project where we're working on that. However, that's kind of like out of the, here. So as far as your Moorish American nationality in here, all you'll really see is an L or a bay in this part. Okay. I hope that makes sense. So will and testament first, to appoint the executor for the estate. Who's the executor? That's the commander, representing the owner of the vessel. So in our case, the commander or the owner would be the L, Bay, Day, or whomever is in that position, demonstrating that the estate is not bankrupt. Or someone else that we may appoint as the executor, which could be, your brother, your sister, wife, whoever, somebody from the Moorish American national government. Once you have that executor letter, then you go into, it's not listed on here, or I do have it here, power of attorney. Why the power of attorney? Because the power of attorney is the proper segue into the commercial system, and we have to resolve matters in the commercial system. So I would just kind of say it, I would kind of leave it like that. Well, I'll bring up this important point too. you have to be very, when you're doing this kind of research, estate trust law, you cannot assume that the role of an executor carries over into a commercial jurisdiction or a commercial, let's call it zone, or let's even say a civil matter. Sometimes we have, we look at the rights of a particular office, but we don't know how to rightly separate which jurisdiction it applies to. So what I believe we found is, just to be more precise with our demonstration, is that the executor deals with the estate, which is estate trust law. He's on the land. He has the right to the property, and everything that's common law and constitutional and probate court will be where the executor resides. Probate courts are the constitutional courts that deal with constitutional matters, and they always deal with matters of record. Okay, so where was I going with that? Kind of lost my train of thought a little bit. So anyhow, this is where I'm going with it. So as the executor, you are within a certain, let's say there's boundaries, because an executor cannot necessarily, if you think about it, cannot necessarily be recognized in the commercial system as we know it today. Not our executors, because that would be to say that we are a part of a bankrupt estate. If our executors could be recognized in a commercial system where we're not using money of substance with silver and gold as is accordance with the common law, right? That will have to be evidence that the executor has abandoned his post and is under bankruptcy or conservatorship, right? In order to be in that debt-based system, to physically be in there, so to speak. So when commercial business has to be conducted for whatever possible reason it may need it to be conducted, the executor cannot, the only way that the executor can carry his rights from on the land into the commercial zone is through an agent. And when you look into the law of agent and agency, this is where the power of attorney comes in, because a power of attorney or a power of authority can establish an agency relationship, and the agency can do things that the principal cannot necessarily do for himself. So the executor who has the right, may not necessarily have the capacity to act, whereas an agent in commerce has the capacity to act, but whether or not he can act depends on his fiduciary duties. So it's kind of like saying depend on his rights. So where does he get rights from? He gets the rights from the assignment, right? So the estate assigns power of attorney through the executorship, or the executorship hires an agent. Through that assignment is where the fiduciary duties and obligations are laid out. In our particular case, as I've seen it written in the California code somewhere, they positively acknowledge that executors of estates may be attorneys in fact. So to me, that was kind of key, because until I read that, I always took for granted, and I always went upon the understanding that an executor for an estate is automatically an attorney in fact, or has power of attorney. However, I don't think that's the way that is considered when you look at civil matters and commercial matters. Let's put it like that. So as a part of the status correction, I understood that you have to have the capacity to act, which is where the attorney in fact or the commercial agent comes in, and then you have to have the right to act, which is where your fiduciary responsibilities, the office of the executorship, comes in. And once you have the executorship and the agent, the administrator at that point can only administer the claim in accordance with the proper records that have been set before him, which is 1, it's not intestate, right? 2, an executor has been appointed, so he has to fall as a secondary officer in support of the executor. An executor has the right and authority. And then coming in with the attorney in fact, he's the agent. Something else I learned, we deal with powers of attorneys. And even in the master file, I have a general power of attorney. This thing is still being researched, and I'm pretty sure by the time we're finished with the research, or as we go further in the research, we're probably going to find that we don't really even want to so much deal with the general power of attorney as much as we want to deal with specific power of attorneys, especially when we're trying to deal with a specific matter. Because I've realized, we know executors have the right to disperse the property of an estate, so they have the right. But I also was reading, and I think it was under agency or attorney, you know, and look in the Bouvier's Law Dictionary, because that's what I was reading. You will see that you can assign an account to an agent per se. So an agent will have the right to deal with that account, your commercial agent per se, in a matter that the principal may not necessarily be able to do for himself. Remember, the principal being under common law, if you will, or being on the land side, not being bankrupt, and probably necessarily cannot use the bankrupt money per se. So this may be why, if there was a such remedy through bankers' endorsements and bankers' acceptances, it'll have to be done through the commercial agent / authorized agent, or, you know, attorney, you know, a power of attorney, attorney in fact, and private attorney general. So look up private attorney general too, and understand that these things are agencies, and they fall under the law of agencies, and they allow the principal to do things that he can't necessarily do for himself. But it's all based on the law of contract, that you have the right to contract. It's just that sometimes you have to use an agent, just like sometimes you have to use a broker, sometimes you have to use a banker. You know, sometimes, you know, certain things are specialized and you need an agent to perform those functions, but you have a right to do those. But the other thing that I was seeing is that the executor can basically, you know, well, an account can be assigned to an agent. That pretty much gives this commercial agent the authority to settle the account. So I begin to think that maybe some of the accounts that we were trying to settle had something to do with that we didn't set up the capacity the right way, which is setting up proof of the agency relationship, which soon as you give someone a power of attorney, and I've researched this now, when you give somebody a power of attorney, they update the record. Now, once they update the record, they change the status, you know, and they put you and the agent falls under commercial status of agency, which I believe he can then exercise the remedies under that commercial policy on behalf of his principal. You see? So I know I said that over and over again, so I hope it makes sense. But the other thing is that the agent actually owns the account. When you do that assignment, say I'm trying to deal with a student loan, which I haven't applied this technology to it yet, but if I were trying to deal with a student loan, first thing I would do is give the loan officer notice of the agency relationship. And what do I mean by that? He'll have to have a power of authority or a power of attorney put on record. You know, so I can deal with him in the capacity of an agent to change the relationship, to change my ability to act under that commercial system, you know. So I hope that makes sense. And I kind of found that because my time being in the Marine Corps, being a military brat, and just working around the government, even VA, on so many different levels, I know it never really dawned on me why, but now I have a better understanding because I research that whenever you give an agency of government a power of attorney, usually they have a mechanism in place to update that on their record, and they usually ask for it first. If you say you're attorney, in fact, they ask for the power of attorney so they can put it in your file and update your record. And that actually is a jurisdictional change in the relationship, because the jurisdiction is dependent on the relationship between the parties. So I said all that. So after you do the will and testament to appoint the executor, you issue your executor letter, issue your power of attorney. Maybe consider how you can use special power of attorney, specific power of attorneys to assign very specific accounts. That's what I was getting at. I would take the loan officer, I would get the account number, I'll create a specific power attorney, assign it to the attorney in fact, and I would ask that attorney to settle the account, because the attorneys have the right to settle the account. based off the public policy is the way that I would see. So anyways, you get your power of attorneys and all that stuff straight. And then at that point, you execute your living trust instrument or your family trust. And your living trust and your family trust, that will also be that the first time that you would probably speak of that is in your will. Because aside from appointing the executor, you're going to transfer or convey the estate, the living and the decedent's estate, to a trust. And that trust may be your revocable trust, which people like to call the living trust, but let's just call it a revocable trust, because if you die, it's still a trust, but it's just no longer, it just passes to whoever your successor trustee is, if you set it up that way. So you either, it makes sense to convey the estate into a trust, which we'll call a revocable trust, not a living trust, or a family trust, if you want your wife or someone else trustworthy. But now the key is make sure there's a certification or record a memorandum of trust or something in the county, or just some proof that that trust exists, so that your estate might be able to avoid probate. Now again, there's references. I'm just kind of going over this so you can have a flow of what's being done. Now once you do all of those county things, then you can go to the master file. As many people have already seen, the master file pretty much is when you're doing the QSIP search results and you're you're doing the UCC filings and things. Don't think about treasury bonds and redemption and all that, because you might see some different files and things at the bottom of here. They're just down there, but that's not really the focus of the master file. The focus of the master file is putting evidence of that trust on record, and you might do so as the secured party, which is why you use the UCC and the trust registration statement. So you're gonna have to do the further research there. The trust registration statement will be the secured party or the creditor if you use a UCC to title the estate or to title the property. So that trust might be your revocable trust that we sometimes call the living trust, or it might be a family trust or any other trust that you create. But it's important that you familiarize yourself with trust registration statements and how to properly identify yourself as a trustee of some type of trust, under declaration, under agreement, under will, what have you. I always identify myself in a trust declaration statement as an L or a BAY, because usually trusts are operating under common law on the land, and you have the right to operate as a trustee in that capacity. So I believe that's also how we're supposed to do our business moving forward as Moors, in our L's, Bays, and Days. Of course, creating a separation from the vessel person or estate, if we will call it that, known on the birth record, birth certificate. All right, covered a lot of information. So let's see, step 4, you do that, right? You could do your UCC stuff. And again, you don't have to do this stuff in order. And now after that, during that sometime, what I'm doing and what I suggest, what I think is wise, is to do a name correction. As you'll see when you go through the data and read the material, the name correction stuff is pretty much straightforward. I do believe any kind of common law procedure, so you got to get your mind wrapped around common law and what a common law process is. It usually involves some type of publications in a newspaper of general circulation. A lot of courts have these common law procedures in their probate area. And even though, like, for example, so what I suggest, one of the easiest ways to facilitate the name correction is get an ink pen and go to your probate court or go to your superior court and ask them if they have a packet to fill it out. Or you can go home and type it all up and fill it out online. But they may have a package where you could just kind of fill it out. It's pretty much straightforward, so I don't have to say much about that. Most of them work like this. As soon as you fill out that package, you're going to submit it to them. They're going to stamp it, and they're going to give you a show cause order or some other documentation. They say you're going to have to publish this in a newspaper, and then you have to bring them back proof of publication. And then a certain amount of days is going to pass. They're going to have a hearing, and the judge will enter an order declaring or acknowledging the judgment for the name change or whatever. The most significant thing I found to put, you got to do the research. We'll just kind of leave it at that. I think that's important. I'm not saying it's necessary, but to me it's important, because after we correct that matter, we want to go into the apply for the travel card. That's one of the major things we want to do, and we want to make sure that when we apply to the travel card, it demonstrates our El, Bay, Day, Ali. We want to make sure that our appellation is properly demonstrated on that card. We want to be with our turbans or our fez when we have that card. And so that we don't have to deal with, if we already have it corrected if we already got the name declaration corrected through the probate or the common law process, we don't really have to worry about them saying you can or can't put this, put this appellation on the application. Now, some people may be able to do it without get that name correction. Some people may just put an affidavit attached to their birth record. Some people may just change add their L or Bay to the birth record, because getting your name changed in court through the court process, I'm not sure, but I don't believe that changes the name on the birth record. I'm not really sure. I'll keep you posted on that, because I'm in the process right now. So anyway, once those records come back, we want to be able to apply for the travel card. We'll talk about that more later when we get to it. And we also want to deal with the Social Security Administration. Now, this is key. When we deal with the Social Security Administration, they're an administration, so we know that they're dealing with aspects of the agency law. This is why we have already done things on the county to correct the matter of the record and the status and things like that. So we may have to deal with them as an attorney in fact to facilitate whatever things we want to facilitate. And we are still doing a research on that, because, as we know right now, the Social Security is an insurance. It's an insurance policy. Meaning, if there's an insurance policy, then there's got to be a fiduciary. There's got to be a beneficiary. There's got to be a trustee. And under the Privacy Act and the law of agency and we basically know that instead of running from the account, we may want to update the record to reflect the nationality of the owner and the national character and the beneficiary and the trustee and whatever is important. Once we update the record, then it's probably okay to use the Social Security number on a passport application or something of the such, as long as you feel competently that the record has been corrected properly. So that's something that we really want to do. We want to kind of address that before we go into the passport application. We've seen the demonstration that people do when they do not have a Social Security number. And for some people who may have a Social Security number, they just need to go ahead and correct the record for that matter and perhaps use it, and I would like to hear other people's feedback on what I just said there when it comes to correcting the record of the beneficiary and the other pertinent information of the Social Security insurance policy, Social Security number, as opposed to being a proper way to use it on an application, being a proper way to use it and be certain that that is not tying you to a citizenship contract of slavery or something of the such. So again, it all comes back to correcting the status. And there you have it. That's the basics. Now, if you really want to go into it, I just clicked that document there. Okay, so this is what the addendum part, or the most recent update, looks like. I left everything of the original master file exactly as it is, and this is just kind of like the overlay. Some of this, a little bit of it is an overlap. Generally speaking, I found that probate courts of record, probate courts are the courts of record, and they deal with constitutional matters. This would include rights of the estate, etc. However, this is not the same for civil matters, which are not constitutional but commercial in nature. Therefore, one's status deals with rights, which is a matter that must be corrected on the record. You know what I'm saying? So the status deals with rights that must be corrected on the record, and the commercial side deals with policy. That's dealt with a little bit of a different way. The record is the registries of your county under the administration of probate. The UCC is not as significant, in my opinion, when we're dealing with correcting the record for the estate. You know, the UCC is not as significant as what we're about to discuss right now. So our approach is correct status on the record and then deal with your affairs in commerce. So yes, we've kind of did some steps in reverse order until this update. Now, a good tool, I'm always saying, do your research, do your research. So let me name a couple of tools. You can Google the Crab's Universal Technology Dictionary. And when I'm saying Googling them, they have these versions online where you can download them. You may have to figure out how to download it, but you can Google it and you can download this dictionary. And then you can search through the dictionary using your Command F find function. You know, you don't only have to look up the word in the context of the definition. You could look up the word and see where it's being used in other definitions and see what it's associated with. It's a quick way to get a lot of research done. So you can download this free dictionary. There's free Bouvier's Law dictionaries online, which is also an excellent dictionary. I think these are the two best. And then you have the Black's Law dictionary. So you can download those dictionaries and they cite further references in those dictionaries. So this is out of the Crab's Universal Technology Dictionary. The definition of probate: the proving of wills of persons deceased in the spiritual court, either in common form by the oath of the executor, or he says, or to avoid future debates by witnesses also. All right. And then I'm just going to go down here to this other highlighted definition of an administrator. Administrator in trusts or estate trust law. This is from the Bouvier's Law Dictionary. An administrator is a person lawfully appointed. So that means they're appointed by the law with his assent by an officer having jurisdiction to manage and settle the estate of a deceased person who has left no executor, or one who is for the time incompetent or unable to act. So the interesting thing is, you know, perhaps you have an executor, but you are incompetent and unable to act. So the interesting thing is with unable to act. In order to act, you have to have the capacity to act and not necessarily the right to act, because the executor may have the right to act, but may not have the capacity to act. And then we also find that a private attorney or an attorney in fact may have the capacity to act, but whether or not he has the rights depends on his fiduciary obligations. So it goes into what I was saying before, that the executor may also be a attorney in fact with the authority to act in commercial matters, right? So the administrator definition kind of shows you why it's significant that there is an executor, and to have an executor, you have to have a will. So we have the will and testament document, as always. I made some updates to it. So this is kind of the same will and testament as before. I made some updates. This is an update that I should have changed. I should have lined this out. I don't recommend. Well, I mean, I got it in brackets, so it serves the purpose. You could put it in brackets, you know, but we don't really recommend using zip codes tying one to any federal enclave. So again, we appoint the executor for the estate, but we also appoint a successor for that executor, right? So this is kind of like a living will, if you will, because the executor is here right now, and then if the and after, you know, the death, or however would be the proper way to say it, after the passing of the form, then another executor who's still here in the present will succeed to the office of executor, and or, you know, the entire estate gets conveyed to trust. Excuse me, that's the second point. So the first point, as we said, is point the executor, point the successor executor, and also the successor executor can act in the instant that you're considered, or perhaps let's say you're deemed to be incapacitated. Say someone is trying to seize the vessel, or some foreign administrator has come up with some rule where you can't be the executor for that estate, right? Well, you have to have someone who's trustworthy, who is able to act, who can act in the capacity of a successor executor in the event that you're deemed incapacitated, or something to the effect. So kind of makes sense. You see the flow of what we're doing here. And then last, most significantly, you establish a trust, whether it's a family trust, or in this case, we have a Moore Eel James D trustee under declaration of trust. That's the trust registration statement, and it's the date of the trust. So this is where the estate gets transferred to. Now, however, if this is a living trust, then you don't have a successor trustee in that trust, and you pass form, then the executor is gone and the trustee's gone, and you create a situation where the estate goes to probate. So also transfer all remaining estate to the beneficiary of the Moore family trust. So in this example, we have a different trust where someone else may be a trustee. And there's a document here. I printed it right here so you can go read this, because I'm not saying it. I can't give you legal advice or anything like that, because I don't have legal advice to give. But this document probably was written by some attorneys, and it says, how does a revocable living trust avoid probate? It's a really excellent article. You can go in here and read it, or you can just kind of Google this right now. You can find it. And I just kind of copied this article in a PDF version just in case this site, wills.about.com, which is about.com, just in case this site goes offline or something. So do some research in your probate court, the general laws of the state that you're in. Also look at your options for recording the will in other states under the International Wills Act. This is, of course, if you're met with some resistance. In general, most registrars that will receive your will stamp and return a true copy. So I also suggest that when we do our wills, we do them on legal cotton bond paper. We do them legal size. You don't have to do it that way. That's just the way that we do it. So we bring in 2 copies, because in some instances, if you don't bring a copy, they won't make a copy. So you want to have a true copy with you. The true copy is also signed with original signatures. That's the way that we do it. And then I have them stamp my true copy with their court stamp. And if they won't stamp it, that's fine. I'll just take the safekeeping's receipt or whatever documents that they gave, and I will attach it to the true copy. Now, usually, as I said earlier, they'll tell you this is not considered a public record. For a will to be valid, it has to be published. It has to be an active publication, right? So consider this. How might you want to publicize your will if it is necessary for you to establish on the public record that the estate has an executor? You may not always find it necessary. You may be skilled enough to navigate so that when a situation presents itself, you can give notice with your executor letter, notice of the appointment of the general executorship, without necessarily having to have the will in the public record. And I'll show you what I mean by that. Where's the executor? So here we have the executor letter. Let's click on executor letter, and you see I revised it a little bit. James Royal Moore Estate, Executor Office, General Post Office, etc. From Moore Eel James D, General Executor, Estate of James Royal Moore. Subject, James Royal Moore, appointment of General Executor. The reference, right? If your will is already on deposit or in safekeeping somewhere, and you have the true copy of it, and you know the witnesses that signed it, the reference is the last will and testament deposited with the executive officer or whoever's keeping the will on safekeepings. Usually that'll be on the receipt that they give you, and then you put the safekeepings number or what have you. And then this is dear, this should be dear whoever you're sending it to, right? In the matter where you're giving somebody notice of appointment of the general executor. That's kind of the way that I was thinking, right? You can put your registered mail number up here. This is the date. It is wise to use a registered mail when things are serious and they're matters of the estate and they deal with the common law and on the land and the private stuff. It is significant to use registered mail, and if you don't understand why and you don't know fully how to use a notary presentment, you got to go back and learn about notary presentments, because that's kind of significant at this stage of the game. So, but this is self-proving. That's why I said even if the will is not in public record, if you give somebody a proper presentation of notice of the general executor's office and you give them a reference where this can be pulled, and of course if this is an administrator that you're giving notice, they're a U.S. officer, they're administrator, they're not going to pull that record. You can always produce a true copy, but if push comes to shove, you know, you can pull the record. You know what I'm saying? Now, if you don't want to go through giving someone notice of general executorship, maybe you could put the will on public record and include a copy of the will with this. I just doesn't seem like a sound way of doing things. So I kind of like this way. All right, so you're basically saying this is a notice of the appointment of Moore Eel James R. to the general executor effective one date whatever in the matter of James Royal Moore, whereas according to the will, all persons who takes on the responsibility of an executor or trustee without proper authority shall incur a personal liability for loss or damage to the trust property. The record of this matter is the testator's will and testament deposit with the executive office. Then you put where it is. You are here and requested and warranted to update the postal location for, you know, here. And you put the general executor's information there. And let me see here. You have Postmaster General, UPU, Ohio Governor, file copy. Whoever you think needs a copy of this executor notice. Yeah, I'll probably go in and do some more work on this. You're encouraged to do some work on it also. And also, so the point that I was trying to make is if you don't put the will on public record, it's not complete. You know what I'm saying? That doesn't mean anything at this point because a lot of times the will ain't going to be published until after, you know, you pass form anyway. But however, you may find in your research that, no, I do want to publish my will, and they probably aren't going to help you do that in the probate court. Maybe there's a conflict of interest, which is the reason why they won't, because they want to administer your estate. I'm not saying that that's the reason. I'm just saying it's one of the things that stands out to me. So some have thought to record the will behind the UCC financing statement. It is an option. I don't really like that option unless you're doing it so then you could take that UCC financing statement and present it to the county to be recorded. You know, sometimes that's the way. You have to get it on the UCC to get it recorded in the county. If you can, however, get the will recorded in the county, general record or whatever, that's considered public record. Or you can publish the will in a newspaper and things of the such. But don't rack your brains on figuring that you have to do this if you don't have any specific objective of why you need to do it right now. Because later on you will learn something that'll contradict what you've already done. So for me, I have the will on safekeepings and deposit. I am not in a rush to put the will on public record, but I have notice of general executorship that establishes a matter of record. I can use these as records of who the general executor is. I could just opt to put only these on the record. Now, something else I was saying before, where is it at here? Oh, don't tell me I didn't put it in here. Is the power of attorney. The power of attorney document. Where is it at? Hold on. It's supposed to be in here. Yeah, the power of attorney. I don't see it. But this is where I'm going to put this right here. So by the time you get here, you'll be able to click this and you'll be able to see the power of attorney. I'm going to pull the power of attorney up so you can look at it, though. Find the power of attorney. So this will be there when you click on the, I'm going to update this before you get it. So you'll be able to click on the power of attorney. Notice in this power of attorney, and you don't necessarily have to do this. You have to look at the implications of doing this, because in this unlimited power of authority, power of attorney, I actually pointed two attorneys in fact. One is the executor for the estate. The other one is someone that I can trust to acting the authority as an agent for the estate. And this is also if they try to say that I'm incapacitated or one that I can't operate in this manner, then there's a successor, so the document remains valid. So it's basically power of authority, delegation of authority. You want to, something that's key is you want to make sure that it's a clause. If you're going to use two attorneys in fact, make sure that you either, like for example here, under the severability clause, I said the full powers may be asserted individually and severally by either appointed attorney in fact. Because if you don't state that, the laws or the policy in your state may be that both of those attorneys have to act together. So that's just one example of why it's probably best, instead of just using this power of attorney, that you look up power of attorneys and see how your state views power of attorneys, and structure a specific power of attorney that's going to make sure that you have the full power and authority and that they're not going to invalidate the document. This was based kind of off of Ohio. Now, something else we added here is that you execute the instrument. It always has to have an acknowledgement on it. You have the acknowledgement by the notary, but we also have the agent issue an acknowledgement. So the agent is acknowledging the appointment. He's been appointed as power of attorney. The agent is acknowledging it. If you want your secondary agent to also do an acknowledgement, he can do this at any given time by doing a standalone acknowledgement and just attaching it to a true copy of this record right here. In California, they have a document custodian certificate. So a notary in Ohio cannot do a notary in California is not authorized to do a certified true copy. So the way that you get around that is the custodian of the record basically makes a declaration that he has a true copy of the record, and the notary puts an acknowledgement on that. It's called a California document custodian record. Why am I mentioning this? Because, for example, when I have my agency agreements or my powers of attorney and I execute that power of attorney, I know I'm going to have to probably present this power of attorney to the Social Security Administration, probably going to have to present it to the Department of Veterans Affairs, probably going to present it to the credit reporting agencies if I'm trying to correct a matter for the estate in the capacity as a commercial agent or as an attorney in fact. So I would want to execute the original instrument and then get a couple of those document custodian certificates and attach those to true copies of the instrument. Let me see if I can pull that up since we're talking about it. I know I can pull it up. And this is how easy it is to find this. California document custodian certificate. But it might not be the same. In your case, you may just have a notary do a certified true copy if that's what they authorize where you are. Okay, this wasn't the one I was looking for, but this is what has been authorized in here in California. A copy certification by document custodian. This is your alternative to a certified true copy. I, which would be your name, custodian of the, I, whatever your name is, and capacity. I also like to put more ill, trustee, whatever, custodian of the original record. Anyway, here you have it, and this gets notarized, and so that's your certificate by document custodian, where you can't get a certified true copy, but you may have to present notices of executorship or powers of attorney. It's just a little. So then remember, put it acknowledgement on your power of attorney. You could do a standalone acknowledgement also. And then here is at the bottom of here is the executor letter. So I think that these two things should be used together. If you're dealing with a commercial matter, you give them the executor letter and you give them the power of attorney, and you give them to them in the same, because they're the same person acting in a different capacity, but the attorney has the capacity to act, but whether or not he has the right to act depends on his fiduciary capacity, his fiduciary duties and responsibilities. But the executor is a term within itself that already includes all the powers needed by the fiduciary. So you kill two birds with that one stone by sending out those two notices. You know, one is for the estate, one is for commercial matters. So I hope that makes sense. This is just how we see it. And so let me close out of here. Let's go back to here. Go back to the addendum. And so we just talked about that. Now, here you go into look up commercial agent, agency. You can click this. This takes you somewhere where you can do some research. Bouvier's Law Dictionary, Crabb's Legal Technology Dictionary, Black's Law Dictionary. Look up these terms. And then, as I said, once we do these things, we go into the name correction. The name correction is pretty straightforward. You go to your superior court, or it's probably going to be in a probate court. They'll probably give you a package. You complete the packages and you fill it out so that you can add your El, Bay, Day, Ali, etc. Now, by the time I get to any name corrections and things, I want to make sure that I have that executor notice and that power of attorney, because when I complete court documents, I only sign in the representative capacity as an agent, which is an attorney in fact. So most court forms are going to be set up for the so-called individual or their attorney. I'm only doing things in a capacity as the attorney in fact. Another note that I wanted to mention, I haven't had the time to do it yet, but it should be done, is there's a relationship between an attorney in fact and the power of attorney that establishes that relationship, or power of authority that establishes that relationship, and the attorney general, or let's say private attorney general for your estate. So I'm going to do some more research into the private attorney general and determine whether or not I have to further enhance the power of attorney to demonstrate that this is the power of a private attorney general. So it may not need to be said, or maybe it needs to be further expressed. That's some more research that we'll get into. And when that's done, you can expect that, of course, if there's any updates to be made, the power of attorney, which is going to be right here, will be updated. When you click the link, it'll already be updated. So again, we want to have that document first, because when we start dealing with the court records, if they try you, and they might or they might not, you never can tell. Sometimes they will. They may say you can't be this, that. So then you show them the agency agreement, or you demonstrate, right? So I didn't really have to go with that. I mean, I didn't have that problem. They didn't give me that problem. Now, fee waiving. You know, this all came to me after I already put forth the process to correct the name through the probate process. So I didn't get to do what I'm going to tell you now. And I hope that somebody would try this and give me some feedback. From my research, when you're dealing with these commercial, quasi-commercial matters, whatever, you have to operate through an agent because the principal can't do certain things. However, under the commercial law and the administration and the agency law and the occupation and all these things, the agent is entitled to be paid from the proceeds and the distributions and all these things that's going on with the estate. I don't know if the agent is supposed to be paid first or not, but the agent does get paid. But the requisite is the agent has to submit his bill to be paid. So when you're acting for the estate, because you're quote unquote not the person, but you're acting in a capacity as a agent or other representative, the agent is supposed to get paid if he knows how to submit his bill, right? Because they're doing the administration, right? They are doing, so it's almost as in the capacities, when you put on the hat as the agent, you are now bringing everyone in on the same picture. So the administrator or judge is also an agent for the estate. You know, he's an agent for the agent. Basically, when you're the executor and you're operating as a commercial agent, you know, you change, now you have the rights and the capacity to act. The administrator just has to follow along with the procedure at that point. So I say that to say, in LA County, I've seen forms where they're attorney fee waiver request forms. So it stands to reason, if you're doing the business for the estate and you're not the liable party, you're not the surety, you're just there performing in the capacity as an agent, you can get paid. So for example, every time they let you do a fee waiver when you're doing anything as far as administering the person in the court, because they're going to get paid anyway, because it's business for them. They can bond based off of their relationship and their tie-in and their officer relationship with the Treasury. They can bond and have those obligations paid out through the Treasury. So they don't care about your fiat money, whether you have it or not, when you're doing these when they're doing administration on the estate. So you can put in your bill and get paid also. So I say that to say, what I would like to see people attempt to do is, when they put forth any type of common law procedure to correct a record and they're asked to pay a fee, that they fill out a fee waiver form, and that they also put in a bill, that they create a logic bill for the time that they need to be in the services that they performed as an agent, and that they put in the bill and that they put in the fee waiver form. And the funds should come from the same place where the administrator is bonding claims against the estate. Remember, he's an agent. You can't go back there and start bonding claims against your person. That's why certain things in commerce, you need an agent. You have the unlimited right to contract and do these things, but some of these things you have to have an agent to do. For example, if I were to tell you to go withdraw money from your trust fund account, the bank is operating in a custodian or agent in some capacity as an agent, because they're doing things with that system that you can't do before yourself. Anyways, so, check that out. Also, I believe, remember, the agency is operating under the commercial policy. That's where your public law 731048 stat and all the policies that allow debt obligations to be discharged dollar for dollar. But in order to have the capacity to do those, I don't think the principal can do those operating from the estate angle, but his agent can. So I also think being your private attorney general or attorney in fact puts you in a capacity that if they do want to try to say, no, you have to pay this, then you can invoke public policy. And as an agent, you have the capacity. When you assign an account by power of authority or power of attorney, you're giving that account to the agent for settlement. So I believe the agent can use the banker's acceptance under the commercial policy because he has the capacity to do so. It's just my thoughts. Also, when it comes to correcting the record of the matter of the social security number, the agent, once again, the agent, you assign the agent that account by specific or special power of attorney, and then have that agent update that officer. And I know, you might, I know this may sound easier said than done, but you have to know how to put this together. Officers of the United States are required to take those agency relationships and make a record of them. They're required to take that power of attorney and put it on record, and it changes the capacity of things. So, as he said, these are things that we're going to do. We want to correct the Social Security account, or the Social Security trust. We have to do more research on that. I encourage you guys to do research, share the research, because how are we going to resolve the Social Security trust account? Well, the things that we're looking at is, who is the trustee? So can we update the record for the trustee? Do we need to update the record for the trustee? Would that be the executor? Would that be our administration or a representative from our government or whoever? Who is the beneficiary of the record? Is it an individual? Is it an organization? Is it a trust? Can we update the beneficiary for the record? Can we update the matters of the nationality of the owner of the record, the owner/beneficiary? We should be able to update those records under the Privacy Act and all these other type of federal laws that deal with the right to have correct records, proper records, the right to a nationality, and all these things. So once we do this, then we can apply for the national IDs, passport, travel card, or whatever, social security numbers if the matter has been corrected, or not. We put this example here. I'm not advocating or saying this is the way this is done, but this is a link to Lawless America. They got a bunch of things here: powers of attorneys, affidavit. I haven't looked at all this stuff, different notices, a lot of different things here. This is lawfulamerica.solutions. I just put a link here, but in here they have the let's see. Look, they got all kind of applications. There's the application for the passport is in here. I don't know exactly where it is, but here it is. I linked to it right here also. And this is what someone else is doing. You can go off of this if you want to. Me personally, I don't like it in the state that it is. You know what I'm saying? I know people who have done this and it has worked. They've put these zeros in here and they've ended up, you know, a little back and forth, and then they got this. I think a lot of this is good, but I want to really, I mean, and that's why I'm providing it here for research, but I'm always saying put your understanding on it. Don't follow things blindly. But again, I'm not saying that there's anything wrong with this, and this could be correct and exact. What I would like to investigate first is correcting the matter for the Social Security record. And then once you do that, and as long as they don't try to say you can't do that, if you is just as sure as you can update these things on that Social Security record, I say then it's fine and dandy to put that social insurance policy with your on your travel documents, on your you know, because in case you get locked up in another country somewhere, you might need the United States of America to advocate for you until we get, you know, fully in place. Now, we are part and parcel, and that's another thing. So, you know, don't get it twisted. Even Moorish Americans, we are part and parcel. We are citizens of the United States of America. And if you don't understand that, you don't understand the Prophet's demonstration or what he's laid out. That's my opinion, and I'll be glad to build and share that with you if necessary. Of course, I'm not naive to know that there's over 6. You know, you have to look at the you have to put in perspective the terms and the conditions and the jurisdictions and the specific capacity in which you're using the term United States citizen, because in some capacities we obviously have always been, and in other capacities, when it comes to just United States citizens, as are citizens of Great Britain, which are subjects, that's also a definition. It's not the only definition, but we're not a citizen in that capacity. So we're aware of these things. All right. So we'll leave it at that. You know, more to be updated. So I hope you enjoyed this update for the master file. And I'm going to get on out of here because I have some other things I have to do.